Hello, my name is Jeff Spees, and welcome to the first of 3 conversations about death and dying. I'll be starting this today with an old joke. You can tell that it's old because of the technology that is mentioned. It's at least as old as far as today's parlance is concerned. The story has to do with a young professional couple living in Cleveland, let's say in February. And they were getting tired of the stuff. And if you live in Cleveland in February, you know what the stuff is. They looked ahead and saw in a couple of weeks they had a long weekend they could get off together. So they booked flights and resort in St. Thomas and decided they're getting out of town. Well, as that week came, it turned out that although he was going to be able to make it, she had an emergency meeting and was not going to be able to fly out on the Friday when they expected to. She knew she could go on Saturday and was able to change her flights. But he, being the person he was, decided he was going to go ahead. So as he's flying down to St. Thomas by himself on Friday, he's starting to feel a little bit guilty. And by the time he gets to the resort, he's feeling quite guilty. Spirits are down, and he's been spirited a good bit by the Mai Tais he had on the plane. But he thought, I should at least let her know I got here. So he went to the resort computer and signed on and sent her an email. Now, unfortunately, because of his state of mind, he didn't enter the email address incorrectly. Indeed, it did go to a woman. Indeed, it was a woman in Cleveland, but it wasn't his wife. It was the widow of a minister whose husband had died a few days before. She was going through the condolence emails, and this note popped up. She screamed, fell flat on the floor. The kids who were still around because they were still in town from the funeral said, Mom, what's the deal? She said, look, it's from your father. My dearest darling, have arrived safely. Looking forward to you joining me here tomorrow. It's a lot hotter down here than I thought it would be. This is an old joke. It's made its rounds on the web. But it was first told to me by a patient who told me that he had asked his minister to tell it at his funeral. And so as often as I can, I include it at the beginning of conferences and talks. So today is session 1 of 3 of video conversations about death and dying. We started this series with the Dean's Forum with Dean Owens on November 15th. This is a session in which we're going to talk about advanced care planning with some additional information and insight from the influence of COVID-19. Then we're going to talk about suffering and controversial options for end-of-life care, religion and spirituality at the end of life, and hopefully have some Zoom conversations in which we can talk with each other. But today's topic is advanced care planning in the age of COVID-19. I will point out that in the handout that accompanies these videos, there are links to me and to all of the other organizations that I refer to. One thing we would talk about is if there are questions that you really want to have answered during a time of a Zoom conversation, maybe email them to me so that I can do homework if I need to. Okay, so advanced care planning in the age of COVID-19. So what we're going to talk about is the ethical and legal framework and components of advanced care planning in the United States. Spent a good bit of time on advanced directives. briefly talk about what anticipatory physician orders are and how they differ from advanced directives and what effect they have, and a few minutes on the impact of COVID-19 on decision making. So advanced care planning with regard to end of life really encompasses three parts. One is the financial issues, will, estate planning, final arrangements, disposition of your body, planning a funeral service, should you desire to do your own, and healthcare decisions, which is really what we're going to talk about today. So advanced care planning is the process of establishing and communicating your preferences for your future needs. And with regard to healthcare decisions, this becomes important when you become unable to speak for yourself. Advanced care planning can be informal conversations around the Thanksgiving table. It's a great time to have these types of talks if you have a family that's willing to go down those roads. But more often we think of these as legal documents, and that's in that framework that I'm going to be talking about it. So with regard to healthcare, advanced care planning anticipates scenarios involving serious and terminal illness, and then gives a way for a response or your preferences to be made known in that situation. As mentioned, we're going to talk about advanced directives and the two major ones, the living will and the healthcare power of attorney, and anticipatory physician orders that we'll distinguish from advanced directives in a few minutes. Now, the whole point of advanced directives comes down to the issue of autonomy, that a competent adult has the right to accept or refuse virtually any medical intervention or treatment. This is very familiar to all of us who have had a procedure done and we had to sign a consent form that says that we understand the procedure that we're going to have done, we understand the risks and benefits, what the possible bad outcomes might be, and that we agree to go ahead. That's an example of an autonomous act. With regard to advanced care planning autonomy, there is a little history in the United States that I'd like to run through quickly. If you're in my age group, you remember these legal cases, the case of Karen Ann Quinlan in 1976, which was determined by the New Jersey Superior Court, or I guess the New Jersey Supreme Court. Karen Quinlan was a young woman who was in an irreversible coma after that was induced by a multi-substance event, drugs and alcohol. Her body was being maintained on a breathing machine, on a ventilator, and her parents sued her caregivers, the hospitals and doctors, asking them to remove Karen's body from the breathing machine. Their argument was that Karen would not want this. I should say, I clarified, I called this Karen's body. Karen was not brain dead, so this was Karen. The New Jersey Supreme Court ruled that Karen's right to refuse was still valid, even though she wasn't able to communicate it. And they didn't order the hospital or the doctors to remove Karen from the ventilator, but they held them not liable for any criminal or civil penalties. And they encouraged then, and this started the living will idea in the United States, that a person can state ahead of time what they would want done in this kind of situation. The case of Nancy Cruzan, which was 14 years later, this went to the US Supreme Court. The Quinlan case really only held for the state of New Jersey, but the impact was nationwide because of the development of living will legislation. Nancy Cruzan was a Missouri woman who, because of an accident, was in a persistent vegetative state in which her body was functioning, but all upper cognitive, all brain function outside of the vegetative functions were missing. She was breathing on her own. That part of her worked. She was being maintained on tube feedings, and her family said that she wouldn't want this. The countersuit was, yes, but it's just nutrition and that's keeping her alive, and that's not extraordinary care, so this doesn't follow the Quinlan precedent. The Supreme Court of the United States ruled that there was no legal distinction between a tube feeding or a ventilator with regard to the fact that they were both artificial means of maintaining life, maintaining bodily life. And they did not find a right to die, but they did find that this was a valid request, and that the tube feeding could indeed be and should be removed. And this then led to the expansion of surrogate decision-making in the United States, or what in Ohio we call the healthcare power of attorney. So throughout the United States, statutes and regulations were developed on a state-by-state basis, but every state in the United States now has living will and healthcare power of attorney laws in place. This has gone so far as to the fact that if you get admitted to the hospital, at least if you have Medicare, but no, I take that back, if the hospital receives any federal funds, which all of them do because they take Medicare and Medicaid patients, when you're admitted to the hospital, you have to be asked by the hospital if you have advance directives, and if so, and if not, to give you the opportunity to do so. So this is the background of autonomy and advanced decision-making in the United States. But let's point out that that right of autonomy is not absolute. There are some statutory exclusions that vary from state to state. For example, the most obvious example is that some states prohibit a surrogate from asking for removal of life support procedures for a pregnant woman. That kind of thing varies from state to state. Autonomy is sometimes seen, at least in healthcare and bioethics, as a negative right. That is, it is the right to accept or refuse, but not to demand. And this comes to play in this, most obviously in the fact that, for example, medical marijuana laws vary from state to state, and medical aid in dying is legal in some states and not in another. You cannot demand a specific procedure necessarily. But our autonomy is also not absolute by choice. The idea of getting married, at least in American parlance and certainly in the Christian tradition, implies giving one's life to another, or ceding control, at least a little bit, of one's life to another person. We'll talk about this and this next point, stewardship, when we get to talking about religion and spirituality at the end of life. Let me read you a brief paragraph from the Book of Common Prayer. This is from the Burial of the Dead, Rite 2. For if we have life, we are alive in the Lord, and if we die in the Lord. So then, whether we live or die, we are the Lord's possession. So the Christian tradition suggests that we are not totally autonomous beings, but rather we are stewards of our life. Again, we'll talk about that again later. This may be something that some of you are putting a little check mark beside on the handout of something you want to talk about further. Okay, let's talk about living wills. So a living will is a document in which you state your directions for care if you find yourself, or if you are found, in a permanently comatose state, for example, the persistent vegetative state that Nancy Cruzan was in, or if you are terminally ill and unable to speak for yourself. I'll just mention that terminal illness almost throughout regulations implies an expected survival prognosis of less than 6 months. So a living will states your directions for your care if you are in that situation and unable to speak for yourself. You're either in a permanent comatose state or terminally ill and unable to speak for yourself. Usually the living will document directs that you not undergo resuscitation, intensive care, ventilators. It does request comfort care interventions. There is, in most living will statutes, or in many, certainly in Ohio's, there is a separate section on artificial nutrition and hydration, that is tube feeding. This is the part of the Ohio Living Will Declaration, in which you say this is your living will, a little bit of legal things to say that this is the legal document that you are enacting, that you're of sound mind and not under subject or duress. And here's a point about living will, is that you intend, and all advance directives, that you intend this living will declaration will be honored by your family and physicians. So this is an expression of your preferences, and you expect your family and doctors to carry it out. The living will, as I mentioned, becomes enforceable if you're in a terminal condition and unable to make your own healthcare decisions, or in a permanently unconscious state. And you tell your physician not to start life-sustaining treatments, to withdraw any such things that have been started, to issue a do not resuscitate order, and to take no action to postpone your death. Mentioned in the Ohio statute, there is a separate box that you have either initial or don't. And if you initial it, it says that you do not want to have tube feeding started, or if it has been started, you would want it stopped. So that's what a living will is. So the living will has some tremendous value. It is universally recognized through the United States, and as mentioned, there is a reciprocity between states. It is enforceable. Should it go to the legal or court arena, it is your statement and carries the weight of your statement. And because of that, it outweighs others' opinions. Your living will is you speaking, okay? There's a downside, and that is the living will is only in force if you are terminally ill and unable to make healthcare decisions, or in a persistent comatose state. In any other situation, your living will is irrelevant. A living will is often taken as evidence of your thought process by healthcare providers, but there's no reason that they need to do so. For example, when my father-in-law was weakening and it had several respiratory infections, and it was becoming pretty clear that he wasn't going to be able to tolerate much more. Pat, my wife, talked with him and asked him about, well, do you think maybe the next time you get these symptoms, you want to go to the hospital the next time? You want to, what would you like us to do? And he said, well, remember I signed that paper. Well, this is the paper that he signed. The fact that he's having a conversation says that neither of those criteria are in play, so that the living will, the paper that he signed, is really not relevant. What becomes a more valuable directive or valuable tool is the healthcare power of attorney, as it's called in Ohio, sometimes called durable power of attorney for healthcare. That's how I refer to it in my book, but this is the Ohio statute, the Ohio term. This is a separate document from a living will, although most of the time these are executed at the same time. Your healthcare power of attorney designates a person of your choosing and gives them authority to make medical decisions on your behalf when you are unable to speak for yourself. Usually you provide at least one alternate. It can be whoever you choose. The healthcare power of attorney, just like the living will, is universally recognized across the United States and is much more widely applicable. So if you are unable to speak for yourself and need medical decisions to be made, you have this person who is legally designated to be your spokesperson. Again, there are a few restrictions on the designated surrogate, again, sometimes having to do with pregnancy. There are a few other decisions that can't be made. For example, a healthcare power of attorney cannot direct that comfort measures, getting pain medicine, for example, not be done. That's a limitation. But in the Ohio statute, from a practical standpoint, the healthcare power of attorney, the healthcare proxy, is your spokesperson. Here is the healthcare power of attorney form, the start of it. You revoke prior healthcare powers of attorney. You understand what it's about. And it says that this comes into effect when you have lost the capacity to make informed healthcare decisions. Now, this capacity is a medical diagnosis. The capacity to make informed healthcare decisions is different from competence. Having lost competence, or to be incompetent, to be declared incompetent, that's a legal term. A judge declares you incompetent or not. And that says you're unable to make basically any decisions. This has to do with making informed healthcare decisions. And what you need to make out informed healthcare decision is the ability to understand what is being proposed, to understand why it's being done, to understand at least some of the risks of it, and then to be able to make a decision, yes or no. This does not imply that you know all the ins and outs or the medical details, but it's basically, can this person weigh options and make a decision? And this is going to vary from situation to situation. Do you want to take the blue pill before the yellow pill is a bit of a healthcare decision that you might be able to make because you like the blue pill first. To decide whether you want to undergo dialysis when you have advanced Alzheimer's disease, this is a different type healthcare decision in which the capacity would vary. So that's when your healthcare power of attorney kicks in. You name your agent, and there are a couple of, again, there's a checkbox, and this checkbox is a different checkbox. This says that you authorize your agent to get your protected health information. Just by naming them your agent doesn't mean they can have all the details. You have to be able to give them your protected health information, your HIPAA protected information. Okay, and here's one other piece, your guidance to your agent, that your agent will make healthcare decisions for you based on your instructions and my wishes, otherwise known. And this is important when deciding who to name your healthcare power of attorney, that this must be somebody who will respect and speak for you, not choose what they want. Okay? Okay. So that leads to, I think, a really important point. The duty of a surrogate decision maker is to choose what you would want, not what they would want. This, in the past, and this unfortunately still sometimes does play out in, say, an emergency room. My mom, say, is taken to the emergency room, and I'm her healthcare power of attorney. I'm actually not. My sister is. I'm second. I actually had an opportunity to do this in Florida when my mom was hospitalized in Florida on vacation. And I was able to get down there, my sister wasn't. And before I left, I scanned my mom's advanced directives into my phone because I did have to have a conversation down in Florida. And I was able to prove who was designated to speak for my mom, and was able to get my sister on the phone too. Anyway, but let's imagine the situation, and I'll use my mom and myself just as a hypothetical, that mom shows up in the emergency room and she's critically ill. And the decision is, are we gonna put mom on a ventilator? She's got a pneumonia, so she might get better, or we just gonna keep her comfortable. Well, if the emergency room doctor says, well, what do you want us to do with your mom? Well, that's tough. Because what do I want? Well, I know that, yes, I love my mother, and I know she loves me, and I know she trusts me, but I mean, there's some secrets that I have from my mom. There's some things that I've never told her that I feel guilty about. And now you're asking me if I want to kill my mom? But if it's clear that what I'm being asked is not what I want to do, but what would my mother want done? So if the question is not, what would you like us to do with your mom, but is rather, so if your mom were here, what would she want us to do? Well, then I get to be the good boy. I get to honor my mother. And this takes this burden so much, lessens the burden so much. I can honor my mom by knowing that even if I disagree with the decision that I'm making it because that's the decision that my mom would want. The other caveat for advanced directives is that for them to be effective, they need to be known. I mentioned that when I flew down to Florida, I put my mom's advanced directives in my phone. I think that's a great place for your advanced directives. In fact, as I'm recording this, I'm asking myself why I don't have my advanced directives in my own advanced directives in my phone, and I'm going to do that. There was a goal of the Affordable Care Act, what got abbreviated as Obamacare, although it was much more than that the country transitioned to an electronic medical record that would be able to communicate between institutions. And one goal of that was that the advanced directives would be immediately available to anyone. If you're in your RV and driving through the Rockies in Idaho and have a heart attack, that the emergency room in Idaho would be able to access your advanced directives. Now, that hasn't been enacted, and anything having to do with the Affordable Care Act is, well, as I'm recording this at the end of October, is very up in the air. If you don't have advanced directives, if you don't have living will and durable power of attorney, number one, do it. But how do you do it? Your doctor or your attorney are your two go-to sources. A lot of attorneys will offer this as part of the estate planning process. You don't need an attorney to do advanced directives in Ohio. They do need to be the forms do need to be either witnessed or notarized. Hospitals do this all the time with social workers as the advisors. There are online options available, and in the handout for this lecture, there's a link to the Ohio forms. Okay. So, advanced directives. We're going to switch gears just a little bit because advanced directives, the living will and the healthcare power of attorney are requests or even demands by you for someone else to do something, specifically for your family or the healthcare system, your doctor, to act on your request. They rely on someone else. They rely on the doctor to write the order in the medical record. Anticipatory physician orders, that's what I'm calling them. These are doctor's orders that come into play when the situation arises. The example from my practice, I spent a good deal of time as a hospice physician, and most of our patients had do not resuscitate orders. I'm going to talk about that in just a second. And I told them to put it on the refrigerator, put it on the front door, put it someplace where it's obvious in case you're found in extremis, perhaps by a neighborhood do-gooder who doesn't know your wishes but stops over to bring you a casserole and calls the squad. You have that order to tell the squad what to do, because this is an order from your doctor that tells the squad what to do. Okay. So the most common is what it's called the portable do not resuscitate or portable DNR form. This orders that in case of cardiac arrest, CPR or resuscitative attempts, other resuscitative measures not be done, and it orders comfort care. The reason it's called portable is that it follows you wherever you go. That is, it's in effect when you're at home, when you're in the hospital, if you go to a nursing home, in the ambulance, between the two. The order is actually on a piece of paper, but there are bracelets that you can, that carry the weight of communicating your wishes. The Ohio statute is a little complicated. The Ohio statute has two levels of do not resuscitate order. The form just puts in your name and requires the doctor, advanced practice nurse practitioner, or physician's assistant who is responsible for this order to sign it. It does not require you to sign it. I always like it when the patient or surrogate signs it, because that indicates they know what it is. The Ohio form is a little complicated, and in that it provides the do not resuscitate protocol, and the do not resuscitate protocol is you don't start resuscitation, but you do give comfort measures, and the comfort measures can include things like, getting rid of the hamburger that you're choking on, or starting oxygen for if you look like you're short of breath. But the difference is when that order comes into effect. The do not resuscitate comfort care says this is the order now. That if you get into a situation like that, the goal is your comfort, and nothing would be done to prolong your dying. The do not resuscitate comfort care arrest option says that you will be treated like any other patient up to the moment your heart stops. This could mean ending up in the hospital, in the intensive care unit, on a ventilator. But that if your heart stops, everything is withdrawn. Okay. Now, this creates a good deal of complexity. And in your handout, I've included a link to the page on the Ohio Department of Health's website that explains the DNR process and actually includes a 40-slide, 30 or 40-slide PowerPoint presentation going through the Ohio's DNR statute and distinguishing between these two. I understand the words, but if I can, any of you look it over and feel like you can really explain it to me, feel free. But that is the statute, and this is the form. Now, why would you want to not have CPR? Well, let's talk about statistics for CPR. On television, CPR works most of the time. We know what it looks like. Actually, we know what bad CPR looks like because usually on TV, the CPR is very bad because to do real CPR on a person hurts. Not so much you, but it hurts the person and can be injurious. But what's in the real world? So CPR was developed as a way to initiate a bystander response in the event of a heart attack or someone's heart stopping. The idea was to save lives in an instant. And in a public witnessed cardiac arrest, with immediate bystander CPR, with quickly getting the automated external defibrillator, which is the best thing with regard to CPR, prompt arrival of the squad, about a quarter of people make it to the hospital alive. And only 1 in 10 are discharged alive from the hospital. So this is kind of best scenario. And it does happen. My dad underwent bystander CPR, was transferred to the hospital, and survived in good neurologic condition. So it can happen. It does happen. But it doesn't happen most of the time. But if you add in chronic disease, frailty, the success rates approach negligible. And this is astounding because in the hospital, most patients do not have DNR status. Most people are full code. And resuscitation attempts in the hospital have notoriously poor outcomes. In general. And CPR is not benign. Good CPR breaks ribs. It hurts. And mediocre CPR or prolonged CPR risks lack of blood flow, lack of oxygen delivery to your brain, and significant neurologic disability in the future. Okay. So that's kind of why you might want to think about whether you want to have CPR or not, especially if you have chronic illness. Now, the DNR form in Ohio has 2 options. One, you want to be a DNR, a do not resuscitate person. By the way, use the link if you're looking for the form. Use the link if you're looking for the Ohio DNR information. Use the link on the form. Don't try and Google it, because if you Google Ohio DNR, you end up with the Department of Natural Resources. But that 2-level Ohio do not resuscitate protocol is intended because there are nuances. But unfortunately, the nuances aren't really covered in that protocol. You either kind of get everything except resuscitation, or you get only comfort care. There may be gradations. Some states, but not Ohio, have enacted physician orders for life-sustaining treatment, or sometimes called medical orders for life-sustaining treatment, to try and get at those nuances. And a POLST, again, is a physician order that anticipates scenarios and orders desired in interventions. For example, this is particularly useful for patients with dementia in facilities who might not be able to make their own decisions, and especially for those whose healthcare powers of attorney are not nearby, or maybe, and this tells the facility what to do. If I get pneumonia, do I want to go to the hospital and get IV antibiotics? Do I want to stay here and in the nursing home and get oral antibiotics? Do I want comfort care only? Do I want to go on a tube feeding or not? If I fall and break my hip, do I want to go to the hospital and try and have it pinned or not? So this is the idea of POLST. It's not wonderful unless it's really part of an integrated chain of communication system that really doesn't exist most places in the United States. In Oregon, they have a system that works better, but in any event, POLST is not available in Ohio anyway. So we've gone through advanced care planning in general, talked about advanced directives, the living will, the durable power of attorney for healthcare, or healthcare power of attorney. We've talked about physician orders for end-of-life care, the portable DNR and the POLST. And that's kind of the nuts and bolts, and I'm sure there are comments and questions and criticisms, and we'll look forward to talking about them. But let me add just a bit at the end here about what we're going through and what the COVID pandemic has done or does to medical decision making. So these are some statistics from early Chinese data, but they're still being quoted as the data. I saw a review just this week that used these data as a description of how people do, or what COVID infection does. Now, the COVID, serious, severe respiratory syndrome virus type 2, I won't get it. Anyway, the novel coronavirus. Most infections with the novel coronavirus, the virus that causes COVID-19, coronavirus infectious disease of 2019. Most infections with this virus are asymptomatic. Most people who get it don't get symptoms, and that's what's made control of the pandemic so difficult when people don't take universal precautions. But of those who develop symptoms, about 4 out of 5 get mild or moderate disease. Mild or moderate disease is not just a sniffle. This is usually fevers, chills, muscle aches, loss of taste and smell, and may include pneumonia, as long as that pneumonia doesn't take up more than half your lung space or cause you to be short of breath. So mild disease can be pretty sick. And of the 20%, the remaining 20% who get symptomatic infection, about 3 or 4 get severe disease, and about 5% or 1 in 4 get critical illness. Severe disease is that which requires hospitalization, that you're unable to maintain your own oxygen level, for example, with pneumonia, start having organ dysfunction, heart dysfunction. Critical illness says that your body is unable to maintain itself without support. So these folks end up being hospitalized. Now, what happens to hospitalized patients with COVID? Well, about 1/4 to 1/3 of patients who end up in the hospital with COVID end up in the intensive care unit. And most of the time, this is because they can't breathe on their own, that they require a ventilator. Other reasons for hospitalization would be for if you're unable to eat, for fluid support, for good respiratory therapy, oxygen, things like that, treatment of comorbidities. But anyway, so this is what happens to those who are hospitalized. And of those, about 1 in 4 people who go to the hospital with COVID die there. Many of those are people who were placed on a ventilator and were unable to be weaned from the ventilator, who developed multiple organ failure and died on the ventilator. And there are some patients who decide after they're at the hospital that they don't want to go down this ventilator road in intensive care and become, change their status to a comfort care status and die in the hospital. Okay, so that's kind of the risks and statistics. But there's other considerations. So what about, let's talk particularly about these folks. So dying in the hospital from COVID-19 means dying alone. In hospitals and healthcare facilities, visitors are markedly limited. I wish it were not so. Every institution is trying their best to figure out ways to put family members and patients in contact with each other because it is vital for being a human being. But it is a challenge. If you are dying of COVID-19, the hospital simply cannot have your family members coming and going and wandering through the halls of the hospital. It just cannot be, because they're getting exposed to you every time they see you. And if you're hospitalized and get better, where do you go? A lot of times after a hospitalization in which someone is this ill, they require a stay in a rehab unit, either in the hospital or in a nursing home. But the rehab units that are in nursing homes or freestanding rehabilitation units, they don't want you. They do not want COVID patients because they've got enough problems, thank you very much, limiting the spread of the disease in their institution. Are you able to go home? Well, if you go home, or you decide that you're not going to the hospital and that you're going to stay at home, and you require assistance, who's going to do it? My wife and I had a conversation about this, and we decided early on that if we got sick enough with COVID that we would need to go to, we would require hospitalization, that we weren't going to go. And we committed to care for each other, knowing that that puts us at risk. Now, we live by ourselves in our own home. We're both retired physicians, and we would get hospice help. But hospice help is tremendous. I'm a gigantic advocate, but it doesn't provide 24/7 personal care. And traditionally, family members have cared for people after they leave the hospital. But do you really want your daughter, who has 2 elementary school kids at home, to be your caregiver and risk becoming infected herself so that she can't go home and be with her kids? Or worse, that she gets sick or dies from caring for you? COVID has added unbelievable complexity to decision-making and advanced care planning for all of us. So, advanced care planning, bottom line. The whole point of advanced care planning, advanced directives, physician anticipatory orders, is for your choices to be made, respected, and carried out. As I mentioned, if you Choose a surrogate decision maker, a healthcare power of attorney carefully. Communicate with them openly and honestly ahead of time. It markedly decreases the stress on them when the time comes that they need to make those decisions. The most common cause of death is being alive. You will need this. Most Americans die after a period of declining function, declining health, worsening disease. So that dying is an anticipatable event. You will need these, so do it. Okay. So that was session 1. Session 2, we're going to talk about suffering and some about controversial options for end-of-life care, particularly medical aid in dying, or what used to be called physician-assisted suicide. And then the third session, we're going to scratch the surface of religion and spirituality at the end of life. I hope that in these sessions that I can stimulate questions, discussion points, criticisms, need for clarification that we can then put together in future Zoom sessions. And as I mentioned at the beginning, if there are particular questions that you want to talk about or want to learn more about, maybe give me an email and let me know so that I can do homework if I need to, or figure out how to include this in the future Zoom session. We'll be able to do give and take, that's fine, but if I need to do some homework and research about a particular issue, I want to be able to do that. So thank you for joining me, and I look forward to further conversations. Thank you very much.